Today, we're going to talk about a unique part of Florida probate law that affects many surviving spouses. Specifically, your right to elect a 50% ownership interest in your spouse's homestead instead of receiving just a life estate. This is governed by Section 732-401, Part 2 of the Florida Statutes, and it can have a major impact on your future, your children's inheritance, and your ability to sell or live in the property after your spouse passes away. Let's start what happens by default under Florida law if your spouse dies and you're not a joint owner of the homestead property. If your deceased spouse owned the property in their name alone and you're still alive, and if they had one or more descendants, like children from a prior relationship, then you, as a surviving spouse, are entitled to a life estate in the homestead. A life estate means you can live in the property for the rest of your life, but you don't own the property outright. So when you pass away, the property automatically passes to your deceased spouse's descendants. So while you can live there, you can't sell the property without their permission. And you may still be on the hook for property taxes, maintenance, and insurance. This can become especially difficult if the surviving spouse and the children don't get along. Here's where Section 732-401, Part 2 of the Florida Statutes comes in. Florida law gives a surviving spouse a choice. Instead of accepting a life estate, the surviving spouse can elect to take a 50% ownership interest in the homestead property as a tenant in common with the deceased spouse's descendants. This means you become a 50% owner and the other 50% is owned by your spouse's children or other heirs. This election must be made within 6 months of your spouse's death, and it must be recorded in the official records of the county where the property is located. If you make this election properly, you'll no longer have just a life estate. Instead, you'll own half the home, and you'll have rights to sell, transfer, or even force the sale if you choose. So why would a surviving spouse elect to take 50% ownership instead of a life estate? There are really a few reasons, the first of them being flexibility. With a life estate, you're locked into living there, but with a 50% interest, you could potentially sell your share or negotiate with the heirs to buy out the other half. Avoiding conflict. If your relationship with your stepchildren is strained, it may be easy or better to own part of the property outright rather than being a life tenant under their future ownership. And future planning. If you're considering selling the home, downsizing, or using the value for long-term care planning, a 50% ownership interest may give you more freedom. And lastly, control over repairs and expenses. As a life tenant, you're responsible for maintaining the property, even though you don't own it. Electing a 50% ownership might make it easier to share the burden or sell. But it's important to understand the trade-offs. Once you make the election, it's irrevocable, and this means your stepchildren now own the other 50% of the property. That can sometimes lead to co-ownership disputes or even forced partition actions. So here's how to properly make this election. You must file a formal notice of the election to take the 50% interest within 6 months of your spouse's death. That notice must be signed by the surviving spouse or their legal representative if they lack capacity. It must be recorded in the public records of the county where the homestead is located, and you must serve the notice to the personal representative of the estate if there is one. If you miss the 6-month window, you lose the right to make the election, and the default life estate will apply. This is why it's critical to speak with a probate attorney early, because once the deadline passes, your options are limited to the life estate. So to recap, by default, surviving spouses receive a life estate and homestead property if the decedent has descendants, like children from a prior relationship or marriage. But under Section 732-401, Part 2, you can elect to take a 50% ownership instead, giving you more control but potentially leading to co-ownership with your spouse's heirs. The election must be made within 6 months and must be properly recorded and served. This decision can significantly impact your future and should be made with the guidance of a knowledgeable probate attorney. If you're dealing with the death of a loved one and need help navigating your rights as a surviving spouse, I would be honored to help. Give me a call at 239-220-3100 or visit us at costpluslegal.com to schedule a free consultation. Also, if you found this video helpful, please give it a thumbs up and subscribe to my channel and leave your questions or comments below. I personally read and respond to as many as I can. Take care, and I'll see you in the next